So I'd like to welcome everybody to our wrap-up live class on the application of the EU state aid rules to renewable energy support. And our focus today is understanding how the European Energy and Environmental Aid Guidelines of 2014 apply here. Now, what I want to do today is to relate how these guidelines adopted back in 2014 are of relevance to some of the measures that are being adopted under the Clean Energy Package. And in particular, I want to look at the recast of the Renewable Energy Directive, which we know has now been agreed upon at EU institutional level, and a draft text is available of that directive, that draft directive. It's 200 pages long. It's quite a document, and of course it's not final yet. There could be still some drafting to be done, and so the text that we have is not yet the absolute final text, but it gives us, I think, something to go on. So what I want to do today is to just talk a little bit about the background to the Energy and Environmental Aid Guidelines. I want to compare the coverage of the existing guidelines with some of the provisions of the new Renewable Energy Directive, the RES Directive, to see if the coverage is equal, or are there gaps, are there discrepancies that we can already identify at this stage. Now, one of the themes that caused quite a lot of controversy during the negotiation on the new draft directive was the issue of cross-border participation in support schemes. So one member state opening up its support scheme to production in a neighbouring member state. Now I want to look at what has been agreed, and also I want to look at some cases where that's actually been dealt with under the EEAG in the past. Now the principle introduced in 2014 in the guidelines is that support mechanisms should be market-based, and preferably that support should be awarded by way of auctions and according to the principle of technological neutrality. And I want to look a little bit about that, how that has evolved, and how that might change, if at all, under the terms of the new directive. And finally, I just want to touch briefly on some transitional issues. What will happen once the existing guidelines from 2014 run out and we get a new set of guidelines scheduled for 2020, which will hopefully be fully aligned with the provisions of the new draft RES directive, which enters into force in January 2021. So let's just go into the background of the EEAG. I think it's important to understand a little bit of that background, to understand how the state aid guidelines have operated in the last 4 years. So they are the result of what's called the SAM, the State Aid Modernization Exercise, which was launched by the Commission in 2012 to streamline state aid control. And the idea was to make that control simpler for the Commission to apply, but also for member states to understand. So that meant that for the first time, we got a set of guidelines that covered energy support and not just renewable energy support. In the previous iterations of these guidelines, dating back to 2000, and they were renewed again in 2008, the so-called environmental aid guidelines did give some rules for support for renewable energy. In fact, very generous guidelines allowing that aid to be compatible. The 2014 guidelines are tougher, as I'll explain, but they also cover other types of support for energy. Now, we're focusing primarily on renewables today, but I'll mention some of the rules for other areas of energy financial support. Now, an important thing to bear in mind when we look at these guidelines, and indeed the old guidelines back in 2000, 2008, is that they allow operating aid for renewable energy production. Now that's unusual because normally aid that covers the daily costs of producing something or operating plant is not considered to be compatible because you're not really giving an incentive to producers to change behavior. So the Commission prefers that member states grant investment aid, so new types of facilities, meeting new environmental standards, for example. So you're incentivizing producers to build something that they would not normally have built under market conditions. Now, operating aid is allowed for renewable energy until now to compensate for the fact that it has traditionally been more expensive to sell on the market than fossil fuel. And that means that member states have been allowed to compensate for the difference between that higher priced renewable fuel as compared to traditional fossil fuels. Now, one of the things that might become relevant when new guidelines are drawn up after the current 2014 version expires is whether operating aid for renewable energy will still be allowed in the future. And the reason I say that is that the Commission and the Parliament have both recognised that renewable support is decreasing, that renewables are able to compete on the market, that they're displacing fossil fuel, in fact, in many countries. So the question might well arise, can we consider this operating aid, this exceptional form of aid, as still being necessary? And it's interesting to look at the draft Renewable Energy Directive, where in fact they do recognise that support might continue, but it's linked to incentives for new capital investment. So that might be important going forward. Now, the coverage of the existing guidelines is quite extensive, and we've already looked at the rules on generation adequacy during both the online and the residential part of the summer school. There are also fairly detailed rules, for example, on energy infrastructure, and there is a special exemption, which I'll come back to, for support to energy intensive users. These are just some of the examples. Now, as part of the modernization exercise, the criteria for assessment for state aid in all these categories is simplified so that the rules are easier to apply. And that means that energy efficiency support, cogen for both heat and power and heating and cooling, those kind of rules became much simpler to apply. Now, although these are energy measures, they also were covered as environmental aid, compatible environmental aid under older versions of the guidelines. What I wanted just to move on to was that one of the unusual features of the 2014 guidelines was that they introduced a special exemption for energy intensive users so that they would not have to shoulder all of the burden of financing renewable energy. So where member states like Germany, for example, levy quite a high charge on energy users, it's possible for certain energy intensive companies, aluminium producers, chemical companies, cement companies, to be exempted from paying some of that charge. Now, one could also ask, is that an exemption that should remain after the adoption of the new draft directive, and on the assumption that the 2014 guidelines will be reviewed and amended in 2020. If renewable energy is now not so expensive, could we contemplate then a lowering of the subsidy level and then a lowering then of the charges that are being passed on to end consumers, for example? If that's the case, then would that exemption from those very charges still be justifiable? So another issue that is open. And one of the issues during the debate on the Renewable Energy Directive was whether or not it should contain a provision requiring member states to ban subsidies for fossil fuel. Now, that was quite a heated debate, and of course it was opposed by a number of member states, so the recitals to the new directive only require member states to use best efforts to phase out that kind of subsidy. So as long as fossil fuels are subsidised, one could imagine that renewables will also have to be subsidised to kind of keep up so they can still obtain market share. Okay, so coverage issues. Now, the main difference with the current situation and the future is that we will have a target to meet that so much electricity should be generated by renewables, but we will no longer have national targets. So by 2020, member states should have met their targets under the current RES directive. They are binding national targets, but going forward, we only have the binding EU target of 32%, higher than the Commission originally proposed, but still non-binding at national level. So it's important to remember that just because the RES directive mandates that member states all contribute to this EU target does not mean that everything they do in the field of renewable energy support will be automatically considered compatible with EU state aid rules. On the contrary, it's made clear throughout the RES directive that everything is without prejudice to the exclusive competence of the Commission in the field of state aid law. It's also made clear that many of the reporting requirements under both the draft RES directive, but also the new governance regulation, which has also been finalised during the June negotiations, the text has been finalised. That will impose very extensive reporting and assessment requirements on member states, but that type of reporting is no substitute for the application of the treaty rules on state aid, that is here Article 108, which requires that member states must notify plans to grant aid to the Commission and should not pay out any aid until the Commission has issued its clearance. So it's no excuse on the part of the member state to justify non-notification just because they assume that the aid is going to be compatible anyway. Now, we can, however, assume that once the support is notified, that it will be assessed under the 2014 guidelines up to their expiry, which is scheduled for the end of 2020. And as I mentioned, the new RES directive should only come into effect in January 2021. But it's also important to remember that if a measure is not covered by the guidelines, then it will be directly assessed under the treaty. So that will be usually Article 107, paragraph 3C, which allows aid for certain sectors or certain types of economic production. Finally, I could mention that small amounts of aid to the energy sector do fall under the block exemption regulation. So they might be aid, but they're assumed to be automatically compatible forms of aid, and therefore they don't need to be notified. And that block exemption, current version, was adopted also as a result of the state aid modernisation exercise, and we could see further reviews of that regulation in 2020 in parallel with a review of other sets of guidelines, including the 2014 guidelines. So, it might well be that the new version of the EEAG could already be adopted before the whole SEP enters into force. We don't know. The last time round, this was a fairly controversial measure, and the member states opposed a lot of the Commission's ideas about revising energy aid. So it took some time to get agreement. The guidelines, of course, are soft law. They are not legislation, but nonetheless, they are binding on the Commission. So the Commission exercises its discretion in a particular way, and it does so by adopting those guidelines. So member states know what to expect from the Commission. They know how the Commission will assess their aid. So the guidelines have an important function in framing national policy in the energy sector as compatible forms of aid. So it could well be that the Commission will launch the process of revising the guidelines already early next year, with the aim of making sure that by 2020 we have a renewed set, but much will depend on what they can negotiate with member states as to whether or not we will have a complete and revised set of guidelines before the SEP enters into force. But on coverage, if we look at what we've got at the moment and what we have in the RES Directive, which imposes quite ambitious targets, for example, on e-mobility, introduction of electrical vehicle networks, electrical vehicles, batteries, intermodal transport. Those are areas which are not covered by the existing guidelines. So one could expect that the Commission would not just want to adopt decisions declaring these types of areas to be compatible on the basis of the direct application of the treaty, but rather it would want to encourage member states to develop good practices, and I think we could expect more detailed guidelines in these areas. Now, the Commission has adopted individual decisions on Norway, for example, the UK, the Netherlands. There have been quite detailed compatibility assessments of national plans to roll out electrical vehicle infrastructure, but we don't have a stable set of guidelines yet. Another area where we might see some development is on green gas, power to gas, biofuels. There are rules in the current guidelines for biofuels where the aim is to substitute existing fossil fuels, but these are fairly basic rules at the moment, and I think we could expect, given that the recast of the RES Directive introduces very complex provisions on when biofuels can be supported or not, and the types of biofuels that will be eligible to count towards all the targets. I think we can expect to see that the rules will have to be expanded and clarified in this respect. Okay, another category which is also worth watching is storage, because as we know, in the new market design, storage becomes much more important. What it is also becoming more controversial. It's not just a big tank where you pump in gas, for example, and wait until the price is right to release it on the market. Storage, especially for electricity, will have a very essential function in the new electricity market. And the big question then is, how do you categorize that type of storage? Do we say it's an infrastructure, or is it equivalent to a form of production? So we need to rethink some of the usual categories in which we classify measures for the purpose of state aid assessment. So we might expect to see some clarification on that front too. Okay, so the next thing I wanted to look at was cross-border participation, because in the early drafts issued by the Commission and supported by the European Parliament, the Commission had wanted Member States to open up their support schemes, their national support schemes, to a fixed percentage of production from other Member States. So this is all about promoting the internal market. However, I see we've now got Henning there. It's a bit late. I hope you could catch up, Henning, by logging in later on, because I think the video will be made available. Okay, so cross-border participation. What we see now in the final version of the new draft is that the member states have won this bit of the fight, and they will only be required to sort of use their best efforts to open up their systems to cross-border participation. So no fixed percentages. I'll come back to the rules in Article 5 of the new recast in a minute. But one of the interesting things about cross-border trade in renewables has always been, well, how do you know that it's green? There's always quite a lot of suspicion that there is greenwashing taking place, that grey electricity or brown electricity is being supplied with a guarantee of origin that was once linked to renewable electricity. And unlike gas, which you can trace through a system, you cannot really follow electrons once they're put into a system. You've no idea whether what you put in is what somebody else takes out. So there's been a lot of discussion about how to deal with this issue. Now, one of the big question marks also from a state aid point of view is if a member state issues green certificates, because often that's part of the subsidy scheme that producers are able to show that they have produced electricity, and suppliers can show they have bought it by means of producing these green certificates, which they can also trade. They have an independent value. And if a green certificate is a tradable, intangible asset, then it's treated then as a possible source of revenue for the state. The state should sell it. And as we know in Poland, for example, there was a long discussion about this, and the Commission eventually decided that the Polish Green Certificate Scheme was a form of state aid. But what about guarantees of origin? You have to keep the two distinct. A guarantee of origin is a proof that something is green, that the thing that has been supplied is green. So it's not the same as a green certificate. It's not something that is normally traded. It might be, but it normally is not. And where it just functions as a proof, then it will not be seen as some kind of an asset which the state should have sold and raised money from. But what is very important in the current discussion about guarantees of origin is that many producers and major buyers of green electricity have lobbied hard to make sure that member states can introduce rules to encourage renewable power sourcing through long-term power purchase agreements, and in doing so to link the physical production of electricity, of renewable electricity, with these guarantees of origin. So the guarantees of origin must be supplied with that power. They cannot be traded or sold off separately. It's up to member states to decide what they want to do it, but it's quite clear from Article 19 that this is left to their discretion. Now, with regard to green certificates and guarantees of origin, again, we're not getting into completely new territory just because the the new RES directive has included this new Article 19. We do have rules in the EEAG on green certificates, and you can see the EEAG assumes that a green certificate is something that the governments issue and allow to be traded, so they must be sold at market prices. So if you don't do that, then you have a problem because you've given, as a member state, a form of state aid, which you should notify and have cleared. So that is an example of something that we do have rules in the EEAG. And we can see also from recent decisions that cooperation mechanisms have already been introduced in a number of countries, maybe anticipating some of the rules that we will see adopted in the new recast directive. And so member states have already experimented with cross-border participation, cooperation with producers in other member states, and have, of course, devised their own rules for doing this. And you can see in some of the decisions I've listed here examples of where a member state has, for example, in the case of Estonia, concluded what we call a statistical transfer agreement with another member state, and has set up a way of auctioning these transfers. Now, these types of statistical transfer agreements will, in the future, be more closely regulated under the recast, and you will see that dealt with in Article 8 and 13 of the RES recast, where we will now have very detailed rules on when you can include these transfers, what type of agreements you will need, rules to stop double counting, because of course the Commission doesn't want, let's say, Estonia to be counting something towards its renewable targets that's produced over the border, let's say in Latvia, and Latvia is counting it as well. That will not be allowed. It's not allowed now, but they now have clearer rules to stop that happening. The idea that you should open tenders to participants from other member states has already been included in a Belgian regime. I hope you can get the number on the slide. It's not very clear, but we can adjust that. There you will see that Belgium, in fact, opened up its auctions for production for wind farms outside Belgium, up to a rather minimal share of 2.5%, just over 2.5%, but still, it's a step forward, a little step. But what we will see on the basis of Article 5 of the recast regulation is that these types of arrangements will have to be subject to cooperation agreements, so that it's quite clear on what terms member states will allow producers to participate in their auctions. And the rules on the cooperation agreements can be developed further under delegated acts, but for now, the most extensive rules for cooperation agreements actually relate not so much to cooperation between the member states, but to cooperation between member states and third countries. There you can see the Commission has proposed and the Parliament has accepted fairly detailed rules on the types of cooperation agreements that will have to be in place so that producers from non-member states can participate in auctions inside the EU. Third countries include, of course, the EEA countries, and obviously Norway, for example, has a lot of potential wind power that it could export. And there are the Energy Community Treaty countries. They too are treated as third countries, but it's expected that we will see some flexibility on the types of cooperation agreements that will be developed with those types of third countries, given that they are more approximated to the EU member states than other countries. Okay, so there are also examples of open tenders, joint support schemes. We can see that in a number of decisions adopted under the EEAG. What's important, as I already mentioned, is that the recast directive does not oblige member states to open up cross-border participation, but it does say that they should strive for in so-called indicative targets, and so up to 5% of the support should be made available to outside participants between the entry into force and up to 2026, and then that should increase to 10% by 2030. However, there is the caveat that member states can ensure that there is proof of physical import, so that might mean that the cross-border participation is really kind of linked to member states that are geographically linked, if you like, or they have common borders. So that will perhaps limit who can do what. And interestingly, there is a review clause in 2023. The Commission should assess whether this cross-border participation is taking off and whether further measures, for example, whether compulsory participation should be allowed. Okay, so hope you're all still with me. Now, as I mentioned, the RES directive is based on the assumption that renewable energy has already penetrated the market in Europe, and that maybe it doesn't have to be on a sort of life support of subsidy schemes for too much longer. So where support is to be allowed, it has to be market-based, and it has to be at the lowest cost to taxpayers. So what does that mean? It means, and we see that in Article 4, how those principles from the recitals are further developed, that the system of support should be market responsive. That means that as costs decline and revenue increases, then the level of support should, of course, be reduced. And the best way to do that is through direct price support, market premium, so the difference between the current market price and the levelized cost of production of the renewable energy in question. So the old tradition of feed-in tariffs, which we still see in many countries, that will only be allowed for small-scale installations, and in fact very small-scale installations. Feed-in tariffs are not market responsible or market responsive because they give a guaranteed price no matter what to the producer. Now, The idea of technological neutrality is also supposed to be market responsive. You have an auction and you invite everyone to apply to deliver the renewables, and it doesn't matter whether it's wind or solar or geo or thermal, you award the contract to the company that comes with the best offer. However, Article 4.3 does provide exemptions. We'll come back to that. But it's important, again, to stress that we already have these kinds of principles in the current EEAG. So auctioning is already the new normal, because it has been compulsory since January 2017. And those of you who follow the debate will know that, for example, there have been quite a few subsidy rounds where, as a result of the auctions, in fact, no subsidies are being paid out, that the price offered was such that no subsidy was necessary. Now, it's always important, of course, for lawyers to know, what happens if you'd already started work before these dates. Are you still eligible for a scheme, or do you have to start all over again and participate in an auction? And in the Belgian offshore support regime case, with the number here, the Commission said no, as long as you'd already started the work before this cut-off date of 1st January, you would still be allowed to have the money as promised to you, and you wouldn't have to stop and start again and participate in an auction, which only seems fair if you'd already started the work. Now, so it is allowed, you are allowed as a member state to award aid without an auction. The guidelines give exemptions from the requirement to auction. For example, if you've only got very few eligible sites for a major wind farm, then it might well be that you don't want to auction that land off. You want to find some other way of making sure that you have more control over the project if land is scarce. There are exemptions from the leading principle of technological neutrality. If applying this would come up with a suboptimal result. So, for example, it might well be that you want to support or promote biomass in the interests of supply diversification. Biomass would maybe not win on a cost basis in an auction against solar power or wind. So in order to promote diversification, you could argue, well, I'm not going to auction and use technological neutrality. So here are the reasons that the guidelines already allow us to promote support without bidding processes and without applying this so-called technological neutrality. So here they are, I've just listed them there. The only thing I want to say about this slide is that the recast directive at its recital 16 recognizes that we can deviate from these principles if we can, as a member state, argue that this is necessary to diversify the energy mix. So you might not want to have an auction if it means that you're just going to get more Russian gas, for example. Right, so that's an important new addition. Small installations, I mentioned that the RES directive contains quite a lot of special rules for so-called small installations, and the directive so far, the draft, actually aligns the definition with what we already have as a small installation in the state aid guidelines. So 6 megawatts for wind power and 1 for other sources such as biomass and solar. So here, in fact, the draft directive is borrowing from the guidelines. Now, final word, and then we have some time for discussion. What happens when we move from one set of guidelines to a new set? Suppose that you're advising someone who has been getting aid under an aid scheme that the Commission has been looking at, but then you find out the member state hasn't notified it. Which guidelines apply? Well, the rule is that when a member state notifies a measure, it should be assessed at the time. It should be assessed under the guidelines that apply at the time of notification. If the member state does not notify the measure and the Commission finds out about the measure, either because of a complaint or because the Commission discovers it's been going on, then the rule is the Commission should apply the guidelines at the time, the ones that were in force at the time that that aid was granted. Those are the rules. There is one exception to that rule, and that is the rule for allowing large energy-intensive users to have an exemption, which I mentioned right at the beginning, that they get this special treatment under the EEAG. This was new, and the Commission actually, when they introduced this new treatment, they said, and exceptionally, we will allow it to be applied retrospectively to exemption schemes from energy charges that were introduced before 2014. So this is quite new. Normally, though, the rules are you take the guidelines in force as the basis of assessment for notified aid, and for non-notified aid, you take the guidelines that were in force at the time the aid was granted. And very last slide. What will happen then in the transitional period going forward? It's really important in state aid law to keep in mind that we distinguish between individual measures and schemes of aid. And if an individual aid measure has been approved by the Commission, then that's it. It stays in place under the conditions that it has been approved until it expires. But an aid scheme, it might have been approved, and therefore any individual measure granted under it will also have been approved. But going forward, when a new set of guidelines is adopted, then the member states are required to adjust the scheme going forward. So it's not meant to have any retroactive or retrospective impact. It's only meant to be an amendment for the future. And it's again interesting that the Commission proposed, and indeed that has been accepted by the Parliament and the Member State at Article 6 of the recast, and you'll see an amended recital 18, that Member States should not, it's not just a may not, but they should not revise existing support schemes without good objective reasons, and they should only do so going forward and with a certain amount of notice to those who benefit under the schemes. So this provision is a result of the many arbitrations that have been brought against countries like Spain and the Czech Republic, who decided their support schemes were too generous, and they cut them back retroactively. So what is a good objective reason? Well, it is, of course, a good objective reason to say, look, the costs of solar energy have dropped dramatically and far more quickly than we could have predicted as a member state. So we are going to reduce the level of support because the producers of solar energy don't need such a high level of support. But that would be a good objective reason, but they should only do that according to Article 6 going forward and not retroactively. Now, what about the European Commission? Could it change its support? It also gives support through all sorts of funds. So will these rules apply to it? Well, there's no mention of that in the directive as such, and it will be interesting to see whether or not the Commission thinks that the financial institutions like the EIB, the EBRD, should be bound by these same types of rules and not cut support or introduce retroactive cuts. It's interesting also when you look at this kind of provision that says a member state must not do something, who will enforce it? Will this be the Commission? Will they take action against the member states for cutting back support schemes? In theory, that could happen. But of course, I think what will be important here is that this provision will give investors an added weapon to make sure that member states offer them compensation if they do change support schemes and this is not justified. Okay, so we have to see how that, whether a member state could be challenged in court. That's possible. That question is being asked. It could be challenged in court on the basis that the state had promised something and then has not delivered, of course. Finally, it should be noted here that the new governance regulation will require member states to provide every 5 years an assessment of their support schemes to evaluate the level of support and to consider whether it is justified in the light of changing technology and in the light of potentially falling costs. Again, it's really important to keep in mind that this is not a requirement for the state aid rules, but you do see in the 2014 EEAG provision that member states can be asked to provide this kind of evaluation. It's not compulsory under state aid law, but it's something the Commission sometimes uses. There is a recent decision on support for renewables in Spain, where in fact the Spanish government is required to provide this 5-year ex post assessment